Hi, welcome to the presentation from the Wisconsin State Board of Nursing to the Wisconsin Nurses Association, Wisconsin Nurses Day at the Capitol. I'm Dr. Shelley Lancaster, and I was appointed to the Board of Nursing approximately 2 years ago. I'm going to introduce the first portion of the presentation today and just speak a little bit about the structure and governance and legal framework of the Board of Nursing. And then Gretchen Lau will finish the presentation and talk about discipline. Next slide. Next slide. The Wisconsin State Board of Nursing is attached to the Department of Safety and Professional Services, which was formerly the Department of Regulation and Licensing. The board is composed of 9 members that include 5 RNs, 2 LPNs, and 2 public members. Each member of the board is appointed by the governor in staggering terms so that the entire board isn't vacated at one time. Each member has been confirmed by the Senate, and we are allowed to serve 2 consecutive terms at the maximum. The Board of Nursing has jurisdiction over approximately 100,000 nurses in the state, and those are comprised of about 85,000 nurses and about 15 to 16,000 licensed practical nurses. What you should also be aware of is that the Board of Nursing, very interestingly, also has jurisdiction over about 42 schools of nursing in the state. Now, when we say 42, those are actually the brick and mortar schools. We also have jurisdiction over the multiple programs that come in from out of state for things like the bridge programs, where you can bridge from ABN to BSN and beyond. So we not only have a large number of licensees, we also have a very large number of brick and mortar schools that we have jurisdiction over as well. So the legal framework, next slide. Next slide. Every nurse in the state should be intimately familiar with Chapter 441, which governs the Board of Nursing legislatively. This really defines the common base of responsibility and accountability and really helps us define our practice within the state. 441 is an interesting document, and I encourage all nurses to go and become very familiar with it. And 441 really governs our Nurse Practice Act and all of the subsequent rules. The first subchapter of 441, the regulation of nursing, really gives us sort of the nuts and bolts and sets forth all of the pieces that govern how we examine nurses in the state. So for most of us, we're familiar with that NCLEX test that's found in 441 and in the subsequent rules. 441 also helps us govern licensed practical nurses, nurse midwives, and advanced practice nurses in the state. Next slide. Next slide. 441 gives us the definition of practical nursing, which is there on the slide, and it's the performance for compensation of simple acts of care. And simple acts are even further defined to say that the act doesn't require substantial nursing skill, knowledge, or training, or the application of nursing principles. And the act is one of the nature of those approved by the board for the curriculum of schools for licensed practical nurses. This really speaks to why it's important as a board to have not only scattered terms, but have both registered nurses and licensed practical nurses represented on the board. Oftentimes when we have questions about how practical nurses are educated in the state, we reach out to the professional group for updates, changes in curriculum, that sort of thing. So it's a very fluid process. If we don't hold the expertise on the board itself, we'll reach out and look for experts within our own state. Next slide. Professional nursing definition is also governed, next slide, by 441. Professional nursing is the performance for compensation of an act that really includes the observation of care for the ill, infirm, sick, and the maintenance of health prevention. Registered nurses or professional nurses are responsible for the observation and reporting of symptoms and reactions of the patients that we care for. And it also governs the execution of general nursing procedures and techniques. What's really interesting about 441 in the rules is that a lot of nurses will look at 441 in the rules and think that somehow they're not specific enough. But when you think about 441 and the subsequent rules, we want them specific enough to define what is a professional nurse, but not so specific that we feel trapped in our own practice. So if you would go to another state, say Texas or Alabama, their rules and acts may be very prescriptive in comparison. And so from a legislative perspective, what we try to do is really help define scope of practice for nurses in the state, but not be too prescriptive that nurses feel trapped by their own Nurse Practice Act. Next slide. The standards of practice for registered nurses and licensed practical nurses are contained in Chapter N6 of the Wisconsin Administrative Code. Next slide. This really governs all scope of practice in the state. And what's important to remember when looking at assessment, planning, intervention, and evaluation is that the Board of Nursing and Chapter 6 and 441 really looks at minimum practice standards. And that was sort of a switch coming from an education background and a really strong practice background. We talk about delivering the standard of care really top-notch at all times, looking at quality outcomes and that sort of thing. And really, as a board, we look at really what is the minimum practice standard. So that was kind of a shift in paradigm for me and in my thinking. Specifically, the rules address the performance of delegated medical acts, the supervision and direction of delegated nursing acts when we're working with paraprofessionals, and really governs how we act in both complex and very basic patient care situations. The rules also govern things like educational preparation, training, and professional experience, and things like education and continuing education. The rules really speak to how colleges of nursing come into the state, how one would initiate a program, how they would seek conditional approval from the state board, how they would enroll students, how those students would then test for NCLEX. So the rules are really specific to how programs would start up, and then how our jurisdiction governs those programs. As an example, if a school was struggling to meet the national standard for licensure and testing through the NCSEN, those rules help guide us in decision-making and helping schools come into compliance with national standards. Next slide. Although licensed nurses are accountable both professionally and legally for determining the scope of nursing practice, the activities have to fall within the broader scope authorized by law. So again, we try to keep the rules loose enough to encompass practice as it changes, but narrow enough that if someone would engage in something, say, that would be outside of the scope of practice, that we still have jurisdiction in handling any issues. So as an example, if a nurse performed an act that fell out of the scope of practice for a registered nurse, let's say he or she was on a medical floor and they grabbed some anesthesia out of the Pyxis machine and decided to anesthetize a patient that was having serious and significant pain postoperatively, that would easily be determined to be outside of the scope of practice. Our Chapter N6 and 441 really gives us the authority to handle a situation like that. So what does it mean? It means that any nurse cannot be directed to perform an act not recognized by the profession as appropriate for our licensure, meaning that no one could really purposefully direct me to act outside of my scope of practice. We use the decision tree. Next slide. The decision tree for RNs and LPNs really help us define our scope of practice. Oftentimes when nurses are in the various parts of the state practicing and working, questions can arise about whether or not a particular act is within one's scope of practice. So the Department of Safety and Professional Services, in conjunction with the Board of Nursing, have really outlined some steps to follow in case we do have practice decisions. We encourage all licensees to be familiar with statutes and rules, and then to use the decision tree put forth by the department. Next slide. And that, again, is to help you resolve the issue at the lowest level. And it's available here on this slide, and you can follow the decision tree. There are alternate resources when it comes to scope of practice for nurses in the state. Next slide. First of all, you can look at the position statements that are available on the Board of Nursing website. This offers some guidance on statute and rules, as well as some opinions from the board. Feel free to look through those and see if you can come to a decision. Next slide. I also want to just briefly mention that we also encourage all licensees to reach out to the Wisconsin Nurses Association, to any of their specialty organizations, for any specific questions that they may have related to scope of practice. The next section, Gretchen Lau is going to take over and talk about how we handle complaints against nurses. I just want to briefly add just a couple of comments about my tenure on the Board of Nursing. In the last 2 years, the board has found some pretty significant issues and problems with both 441 and subsequent rules. The Nurse Practice Act really hasn't been looked at and reviewed since 1981. Most nurses in the state are very familiar with sort of the dynamic way that we practice. And so there are some serious and significant rule changes that need to occur. As an example, the way that 441 is written right now, this seated Board of Nursing can make a motion, and within a week, we could be writing all of our own NCLEX examinations, because 441 was never changed to include the adoption of NCLEX as our test writer. So over the last 2 years, I have gotten intimately familiar with 441 and with the subsequent rules, and I hope in my next 2 years that we can move to adopt the Model Nurse Practice Act as written by the National Council of State Boards of Nursing. So I am the board member who's very focused on updating 441, also very focused on updating the rules to reflect more contemporary practice. I'd also like to mention that many years ago when I came into nursing, Regulatory Digest was delivered to each licensee's mailbox every once in a while. And I remember as a nurse running to the mailbox and reading what was going on in the state, who had been disciplined, and what the issues were that the current board was facing. This newly seated board, and we do have some older board members and some newer board members, has really gotten excited about the idea about bringing back Regulatory Digest so that our licensees can be intimately familiar with the work of their Board of Nursing. As a part of that, we're sort of in this modern age of technology. The board has adopted some really exciting things. First, for the first time in the history of the Board of Nursing, we've adopted a mission statement, a vision, and values. We've opened up a new website, and we hope to have it up and running by June 1st. And quarterly, you're going to get updates from the various chairs on the Board of Nursing and the actual chair of the Board of Nursing, just letting you know what the hot ticket items are for the Board of Nursing. We're also going to reintroduce, as was in Regulatory Digest, we're going to reintroduce a list of who was disciplined in the prior quarter, what they were disciplined for, and then links to read their specific discipline and order. We'll have updates from things like WNA and other practice issues. We'll have the position papers that we're currently working on. We want our licensees to know that we are an open, dynamic board, willing to listen to our members, willing to continue to serve the public in a very open and transparent manner. So as we make these changes in 2013, I'm really excited to see nursing move forward, and that's actually the name of our new webpage for the Board of Nursing, is Nursing Forward. I look forward to continuing to serve the people of the great state of Wisconsin and the almost 100,000 licensees. And again, if you have any questions for this Board of Nursing, please feel free to reach out to us. I will give up the floor now to Gretchen Lau, and she'll talk about discipline. Thank you so much.
The question before us is, how does one file a complaint against an RN or LPN? My name is Gretchen Lau. I serve as a public member on the Wisconsin State Board of Nursing. Next slide. Instructions for filing a complaint. Well, anyone can file a complaint, but nurses, hospitals, nursing homes, agencies, and other employees of RNs, LPNs, or APRNs have a duty to report to the Board of Nursing the names of any licensee or applicant for nursing licensure whose conduct may constitute grounds for disciplinary action. This complaint should not be used for bias purposes, retaliation, or personal disagreements. The complaint form should indicate who made the complaint, that would be the complainant, who the complaint is against, that would be the respondent, and the description of the cause for the complaint. That document would be mailed to the State of Wisconsin Division of Legal Services and Compliance. Next slide, please. What happens to a complaint after it's filed? These are the stages of the complaint process: the intake stage, the investigation stage, the legal action stage, and finally the hearing stage. Next slide. The intake stage. This is the first stage, where complaints may be received from any source and are first screened by a Division of Legal Services and Compliance attorney. Copies of the complaints are then sent to the screening panel. That is consisted of us board members who serve on a rotation basis. We review and evaluate the cases in the packet before our monthly screening calls, where they interact with the DLS, the attorney, to determine if an investigation is warranted. The screening process is a first step in effective and efficient caseload management. The panel considers the seriousness of the allegations, the harm or threat of harm, the prior complaint history, the past handling of prior similar cases, whether the matter as a whole is trivial, whether the dispute is already resolved, and any other relevant factors identified by the panel. Complaints that do not warrant investigation are not open due to no violation, compliance gain, or other factors determined by the screening panel. If the complaint is not opened at intake, the parties are then notified in writing of disclosure. Complaints that appear to have merit or require further investigation are identified for investigative action and a case is open. The screening panel may wish to give the attorney some direction on handling the complaint, such as suggesting an administrative warning. The case is then sent to the division investigator and attorney. Next slide. Investigation stage. An assigned division investigator and attorney develop an investigative plan. The investigator in the case gathers evidence and contacts are made with witnesses. The results of the investigation are provided to the assigned case advisor. That would be a member of the Board of Nursing. We are provided with a summary of the case, with documentation that's relevant to the case, such as medical records, witness accounts, and if possible, a reply from the respondent. These complaints could range from drug and alcohol violations, working outside scope of practice, failure to follow doctor orders, all the way to incompetence in practice. These types of cases are held by the professionals on the board. The public members, which are two of us, are assigned non-medical cases such as HIPAA violations, patient abuse and abandonment, practicing without a license, boundary issues, and things like that. The case advisor then reviews the case materials and provides advice and assistance to the investigative staff and the attorney during this process. The case advisor may ask for additional documents if needed. And after determining the merits of the case, a decision upon appropriate resolution is made. On cases that do not warrant professional discipline, based on the decision of the attorney and the case advisor, these are closed by the full Board of Nursing. This differs from the screening process where the screening panel closes cases. Cases where violations are found proceed to the next stage for legal action. Next slide. Legal action. The DLSC prosecuting attorneys, along with the case advisor, review the results of the investigation and pursue disciplinary action or non-disciplinary action when appropriate. They must weigh various factors in the case, such as whether this complaint was filed in retaliation, whether it's a complaint filed over a disagreement between employees, or whether there is insufficient proof to make a case for prosecution success, or is it a clear-cut incident of violation? The critical step in this stage is the communication between the attorney and the case advisor. These two must make every effort to agree on an appropriate method to resolve the case, and if formal discipline is recommended, decide on a range of desired outcomes. Cases could be resolved by means of stipulated agreements, which would be subject to board approval, informal settlement conferences, or administrative warnings. If a case cannot be resolved in this stage by agreement of the parties, then the case must proceed to resolution through a formal administrative hearing. Next slide. What are the permissible reasons for discipline? Well, we would like to rehabilitate the licensee. We need to protect the public interest. And then there's deterrence for both respondent and others. Case advisors must consider the rationale for discipline. Punishment is not a reason for discipline. Decisions can't be arbitrary or capricious. Things we need to consider as a case advisor: was there a violation of the Nurse Practice Act? Was the conduct ongoing or likely to reoccur? The seriousness of the conduct: was it intentional? Is the licensee a repeater for the same type of conduct? And whether the conduct indicates an underlying incompetence. Next slide. Some examples of misconduct subject to board discipline: impairment, chemical dependency. These would be AODA violations, and they're usually the standard order, which has been 5-year state suspension with testing and other conditions. There are quality of care violations, negligence, incompetence, violation of law, both criminal or civil. Ethical violation, boundary issues, theft, Medicaid fraud, overbilling. HIPAA violations. This would be confidential information violations. Abuse, both physical or verbal. Neglect, such as patient abandonment. The discipline varies depending on the seriousness of the Nurses Act. Some questions case advisors consider: was there harm done to the patient? Are there AODA issues involved? Is this a first-time offense? Does a criminal or civil violation of the law have an impact on the nurse's performance? Does the act fall under Chapter N7 rules of conduct? Did the respondent meet the minimum standards of care? Based on the violation, will education suffice as solving the problem? Next slide. Types of discipline available. As I mentioned before, our first concern must be for the safety of the public. Our jobs as case advisors are to protect the public while also making a just decision for nurses depending on the action of the nurse. So depending on the seriousness of the violation, some of the disciplines that may apply are, and I'll give you some case examples along with this: a reprimand, that's stronger than an administrative warning; a formal disciplinary action because of a violation that has been proved may come with limitations such as continuing education courses. Sometimes a reprimand will come with limitations, and these are imposing conditions and requirements as well as restricting the scope of practice, limiting practice to a certain subject, practice areas, limiting prescribing practice, etc. An example of a reprimand with limitations would be: a community health clinic compliance department monitored access to medical records of a high-profile patient. It was discovered that the respondent accessed the patient's record at least 18 times. Respondent acknowledged she was overly curious, and she looked up the person's information for personal reasons. Also during the investigation, respondent also admitted to reviewing the obituaries daily and oftentimes looked up individuals that sounded familiar to see if they were patients. Well, this was a violation of HIPAA. And so the case advisor recommended a reprimand with order for continuing education in the area of legal aspects of patient confidentiality. The attorney in the case agreed, and the board affirmed that decision with that order. Another form of discipline is suspension. This removes the credential holder from practicing their profession for a specific period of time. It can be imposed or stayed with or without limitations. In AODA cases, there usually is a 5-year order with drug test, treatment requirements, and limitations attached to the program. An example of a suspension would be the respondent was convicted of 3 counts of theft. Respondent billed the Wisconsin Medical Assistance Program for services she did not provide, resulting in a 4-month suspension. The limitations on her license included no employment where she was responsible for billing, no home health care, no pool nursing or agency setting employment. And she had to provide a copy of this current order to her current employer and any future employer that she would have. Also, the next form of discipline we would have would be revocation. This is reserved for the most serious conduct to completely and absolutely terminate the credential and all rights, privileges, and authority previously confirmed by the credential. By statute, the nurse can petition for reinstatement after 1 year unless the revocation was for tax delinquency, and that's set by state statute. This action can also be used for failure to follow a board order. Surrender of license. There may be instances where the conduct is of serious enough nature that a finding of a violation is also necessary, in addition to accepting the voluntary surrender of the license, perhaps an agreement not to practice or a recognition of the retirement. An example of a surrender of a license is Wisconsin and Arizona are party states of the Nurse Licensure Compact, which provides for a multi-state licensure privilege and allows a nurse with a license from a home state to engage in practice of nursing in another state. This respondent was employed by a Wisconsin nurse registry and works for Maricopa County Correctional Health Services in their jail. Questioned by investigators, respondent admitted to bringing in contraband and found methamphetamine on this person. He was found guilty and sentenced to jail. The Board of Nursing accepted the surrender of respondent's license effective immediately. We also, next slide please, we also have alternatives to discipline. These are violations that do not rise to the area of disciplinary action. One alternative would be closure. If the nurse has already educated herself on the issue, or the issue has already been addressed by another jurisdiction or program, or some other reason that pursuing the case would not be worth our resources, the case is closed. An example of this may be the facility employing the respondent may have retained the staff in the area addressing the complaint. We would close this for compliance gained. Administrative warning. This is used for a first occurrence of a minor violation. This is not considered discipline. While the administrative warning is disclosable to the public, the contents of an administrative warning are private and confidential. If an administrative warning is issued, the credential holder may obtain a review of the administrative warning through a personal appearance before the board that issued the administrative warning. We also have alternatives such as remedial education order. This is issued if the violation can be remedied with education, such as course on ethics, boundary issues, or to correct lack of medical knowledge in a specific area. The professional assistance procedure, known as PAP, is a confidential program for professionals impaired by chemical dependency. It is intended to encourage individuals to seek help for their impairment in a non-disciplinary environment. Participants are monitored by program staff for compliance with treatments, drug testing requirements. Violations occurring will evict the participant from program and result in discipline by the board. Next slide. And so we're on to the hearing stage. This is a formal legal process and results if no satisfactory resolution is available at the legal action stage. And only a small percentage of cases progress to this stage. However, the cases that are resolved through formal hearings often represent the most serious cases pending before each of the boards. A formal administrative complaint is filed to request a formal hearing by the DLSC attorney. This is mailed to the respondent. A response to this complaint, called an answer, is then filed by the respondent. And the respondent has a right to be represented by an attorney. Sometimes during this process, A case will still resolve through a stipulated agreement. However, if no agreement resolves, a hearing will occur. And the DLSC attorney litigates this case before an administrative law judge. Both sides present evidence, but the burden of proving that violation of a rule or statute occurs rests on the DLSC attorney. The administrative law judge then issues a proposed decision. The respondent or respondent's attorney may file objections to the proposed decision. It is then reviewed by the board. The Board of Nursing then considers the record in the case, either issues a final decision and order agreeing with the decision of the administrative law judge or not agree with the order, and sends it back to the DLSC attorney for modifications. Next slide. On orders and disciplinary actions, it is important for someone who has been disciplined and is under board order to review that document. And they need to look it over carefully to understand what it contains. What are the education requirements and time allowed to acquire those CEs? What limitations they may have on their license, especially if they're changing employers. When to request a stay. When they can ask for modifications to their orders. And what testing or therapy that the order may be requiring of them. This will keep from future misunderstandings that may happen. You do not have to appear before the board for modifications, but can ask for an appearance if you so choose. Reports of these decisions are published to the web on an ongoing basis following our board action and contains orders issued by the professional regulatory boards and by the department. To access information, there is a URL provided below. In summary, the Board of Nursing is comprised of 9 members who take their roles very seriously, whether it is overseeing the various programs at nursing schools, ensuring students are attending credentialed schools that meet government testing standards. We also must ensure protection of the public. Although it is difficult for us to view many of the serious cases for discipline, we recognize these violations are just a small percentage in comparison to the size of the nursing workforce who dedicate their lives to giving quality patient care. We want to acknowledge all of you for the dedication and professionalism that you show every day in your work on behalf of the patients you serve. Thank you.